Honorable FIDA Global President Ezinwa, distinguished speakers, fellow members and guests. Topic for today is From Formal Equality to Transformative Justice, Dismantling Structural Barriers for Women and Girls. I would like to mention the table of contents. Introduction, structural barriers to gender equality, international legal frameworks, domestic constitutional framework, access to justice and gender-based violence, economic justice, intersectionality, and institutional reform. Conclusion. Introduction, inclusive justice, global strategies for dismantling legal barriers for women and girls. Inclusive justice is not merely an aspirational principle. It is a constitutional and moral imperative. Across jurisdictions, women and girls continue to encounter structural impediments that restrict their access to legal remedies, economic participation, and personal security. The persistence of structural barriers. Legal systems are often designed within patriarchal socio-economic frameworks. Discriminatory laws, weak enforcement, inaccessible legal aid, economic dependency, and harmful social norms converge to create cumulative disadvantage. Formal equality and its limits. Formal equality requires that like cases be treated alike. However, such an approach assumes that individuals begin from equal positions. Where structural inequality exists, identical treatment can perpetuate disadvantage. Substantive equality, by contrast, requires examining impact, not merely intent. It requires courts and legislatures to identify indirect discrimination and systematic disadvantage. Transformative justice as a constitutional imperative. Transformative justice goes further than substantive equality. It demands that institutions actively dismantle patterns of historic oppression. Courts must interpret constitutional guarantees dynamically, ensuring that equality provisions do not remain symbolic. Gender equality and the rule of law. The legitimacy of the rule of law depends upon inclusion. A justice system that fails to protect half its population equally cannot claim institutional integrity. International legal framework. When we talk about international framework, there are many conventions where we have ratified. Especially, Sri Lanka has ratified CEDAW, ICCPR, ICESCR, and also we all know about Beijing Platform for Action. It gives the structural reform framework. Women in power and decision-making and institutional mechanisms for advancement is being mentioned there in the Beijing Declaration. The platform recognizes that equality requires structural reform across political, economic, and legal institutions. Sustainable Development Goals, Equality and Institutions. Goal 5 seeks to achieve gender equality and empower all women and girls. Target 5.1 calls for the end of all forms of discrimination, and then it addresses elimination of violence against women, emphasizes equal rights to economic resources and property. International law in a dualist system. Interpretive engagement. Sri Lanka is a dualist country, so the dualist framework precludes direct treaty enforcement, but still then, after the signature, when we are a signatory, we are bound, we have an obligation to act according to the conventions that we have already signed. So therefore, we are supposed to enact our laws and amend the statutory provisions in accordance with the conventions that we have already signed. Domestic constitutional framework. Equality under the Constitution of Sri Lanka. According to Article 12.1 and 12.2 of the Constitution, it guarantees equality. Sri Lanka enshrined equality before the law, equal protection of the law, and non-discrimination on specified grounds, including sex. It is enforceable only against executive and administrative action, not directly against private actors. It operates within private spheres such as employment, family, or community practices, governing marriage, divorce, and inheritance. Judicial interpretation, reasonableness, arbitrariness, and substantive equality. In Vishwalingam versus Liyanage, the reference is there. Subsequent jurisprudence has been developed proportionality, style reasoning in administrative review for a legal audience. The key question is whether Article 12 permits scrutiny of indirect discrimination, where facially neutral measures produce disparate gendered impact. A gender-sensitive reading of equal protection requires 3 analytical steps: identifying different impact, examining whether the measures perpetrates structural disadvantage, assessing whether the state has provided compelling justification. Without such an approach, constitutional equality risks remaining formalistic. Dhanapala Manikki versus Dayananda Columbage and others decided that gender discrimination under the Land Development Ordinance number 19 of 1935, Rule 1 of the third schedule to amend, provided gender-based order of succession, sons, daughters. This statutory framework gave male children priority over female children in succession to state land, but under the Development Amendment Act, empowers and it was the gender-based discrimination was recognized and ensured equal succession rights even to girl children, regardless of sex. Enforcement deficits, procedure as a site of inequality. Fundamental rights applications must be filed within 1 month under Article 126 of our Constitution. So because of this limitation period that disproportionately disadvantaged some women facing trauma, social stigma, or economic dependency. So therefore, there's a problem in that with regard to women. Structural inequality is reproduced. A justice system cannot claim inclusivity where procedural architecture excludes vulnerable litigants. Access to justice and gender-based violence. Access to justice, a multidimensional doctrine, international covenant on civil and political rights guaranteeing equality before courts. Legal literacy, affordable representation, physical accessibility, linguistic accommodation, and procedural dignity. ICCPR Act 56 of 2007 in Sri Lanka. This is in this act, most of the ICCPR articles are being embedded. So according to this act, women are protected under the law. Right to recognition as a person, right to a fair trial, right to petition the High Court for human rights violations, public affairs and state services, and no explicit women-specific provisions are included, but still all these provisions are available where anyone can have access. Victim protection and institutional accountability. So therefore, soon after recognition of the women's vulnerability, the Assistance to and Protection of Victims of Crime and Witnesses Act is being enacted. So it establishes a national authority empowered to grant interim financial relief and implement protective measures, not even to women, but it's open for everyone, all victims and the witnesses. And there's another act, Women's Empowerment Act, number 37 of 2024, recently enacted, represents a formal legislative attempt to institutionalize gender equality within Sri Lanka's domestic legal framework. Gender-based violence, due diligence and structural analysis. Sri Lanka's legislative response to domestic violence is embodied in the Prevention of Domestic Violence Act, where it empowers women, or even a neighbor could go before a court of law and file a petition when there's an act of domestic violence. Section 363 of the Penal Code criminalizes rape, but when it is taken place within the family by the husband, it is not being addressed. Unless the perpetrator and the wife are being separated, the rape is not recognized as a crime in Sri Lanka. Comparative constitutional innovation. Visakha versus State of Rajasthan in India relied upon FIDA to formulate binding guidelines in the absence of domestic legislation. Similarly, South African Constitutional Court also have been recognized these guarantees. Economic justice. Economic exclusion as constitutional concern. Article 3 of the International Covenant on Economic, Social and Cultural Rights mandates equal enjoyment of economic rights. Where women lack property ownership in independent income, their ability to seek judicial redress is constrained. Jaffna Matrimonial Rights and Inheritance Ordinance in Sri Lanka. According to Section 6, a married woman requires her husband's written consent to dispose of immovable property. These are the places where we have recognized that there's inequality. A husband has full power to dispose of his property without his wife's consent, but wife is not. Wife must apply to district court to dispense with the husband's consent in specified circumstances. Personal laws and constitutional tension. Personal laws governing marriage, divorce and inheritance must be examined in light of Article 12 and 16(1) of the Constitution. The preservation pre-constitutional laws raises complex constitutional questions regarding hierarchy and reform. CEDAW Article 16 mandates equality in marriage and family relations. But still, some laws in Sri Lanka, especially the Tesavalame, and few laws, there are certain differences with regard to women. For legal professionals, the issue is not merely reform, but constitutional methodology. How should courts navigate Article 16(1) in equality education? Financial inclusion as structural reform. Gender inclusive financial strategies, credit access, entrepreneurship, support digital market platforms, reduce economic dependency. However, without legal guarantees of equal property rights and non-discriminatory lending practices, financial inclusion remains fragile. Economic reform must be embedded within legal frameworks that secure equality of opportunity. Intersectionality and institutional reform. Intersectionality as doctrinal tool. It recognizes that discrimination operates cumulatively. A rural, economically disadvantaged woman with disability faces compounded exclusion distinct from gender alone. Equality jurisprudence must therefore incorporate contextual analysis. Failure to recognize intersectionality results in under-inclusive remedies. Institutional legitimacy and representation. The composition of the judiciary, police, and legal profession influences public trust. Gender representation enhances legitimacy and decision-making diversity. Data disregulation is essential. Without empirical evidence, structural reform lacks diagnostic precision. Women lawyers as agents of structural change. The global work of International Federation of Women Lawyers demonstrates that litigation, advocacy, and transnational collaboration are central to dismantling discrimination norms. Women lawyers operate at the interface of doctrine and lived reality, translating constitutional principles into enforceable rights. Conclusion: transformative inequality, the judicial responsibility. Transformative equality requires sustained interpretive vigilance, legislative reform, institutional accountability, and economic restructuring. The judiciary must ensure that equality clauses are not read narrowly but purposively. The task before us is not to rest upon textual guarantees, but to interrogate whether law in action reflects constitutional promise. Inclusive justice is realized not when rights are declared, but when structural barriers are dismantled and women and girls experience equality in practice. Thank you.